The Labour Party will be opposing this legislation. I say that sort of more in sort of sadness and in anger, because it actually contains quite a few provisions that the government, that the Labour Party, I'm getting premature here, supports. And it includes even more policy things which the Labour Party supports, but thinks is unnecessary to put into legislation. So there's a combination of quite a lot of good stuff, including the material that happened late around the Teachers' Council, where there was a degree of cooperation. I mean, I think it's fair to say that there was searching questioning from the Greens at the Select Committee. I think those of us who are slightly more familiar with the problems that teachers can cause in schools and sometimes the urgency of getting it sorted, maybe we're less concerned about process and we're more concerned about the immediacy of kids, and that's and there's always a fine balance, and I think it's fair to say we were just we were on one side of a boundary and the Greens were on another. It's not a big thing or a big division. While I'm speaking about the Select Committee and what happened there, can I thank again Alan Peachey, who chairs the committee. He does well. I think it's fair to say that he does a good job of sorting out what's contentious and what's not, and getting rid of the non-contentious stuff, and identifying if there's any room to move where things are contentious, and if there's not, making it clear and members accept that. And I think the process generally works well. I've never heard someone who's come to the Select Committee saying that they haven't had a fair hearing. And that's not something we could say about all Select Committees. It doesn't mean that people always agree with the results, but that's politics and that's life. So in current circumstances, I wish Alan well. Mr. Speaker, there are some things that the Labour Party disagrees with in this legislation. My colleagues in the earlier stage, Chris Tremaine referred to the inherited rights to attend a state school. Now, it is just a straight question of what one believes in. The Labour Party doesn't believe that people should inherit their rights to attend a state school. And we think that the priority should go to people who live closer to those schools, and the idea that you go further away and give those people rights based on whose side them or who their mother was is wrong. There is an acceptance that the limited attendance centres legislation that the Labour Party introduced fairly late in the government went a step too far, because I think it treated as early childhood education centres areas where there was very short-term care and there was not a propensity education. And I think that with the changes that have occurred now, we've come closer to getting a balance. And I do want to place on the record at the third reading the fact that the campaign of the Labour Party around ensuring that police checks are kept for people who supervise young children at these limited attendance centres have been maintained. It is, and we will vote on in fact, we will support the third reading the Occupational Safety and Health Act changes, which mean that this happened, while we'll be opposing the Education Act changes, which cause it to have to happen, Mr. Speaker. There are some other matters. I want to focus on the Law Commission report, private schools and the law, because I think through the debate this issue has probably not had the focus that it should have, and I think many people work on an assumption that all schools would publish their disciplinary procedures, and that all schools, including private schools, would follow due process in implementing those disciplinary procedures. But unfortunately that is not the case. There have been a number of examples recently. I've got to know a couple of them quite well, where schools have not followed the process. I can accept the fact that I was ignorant in the area. I mean, I was Minister of Education for 6 years, sat on the Select Committee for a couple of years, but was not aware until the Law Commission reported that we had a vacuum in the law around the rules. I accept that the Minister picked up a couple of the recommendations, but I don't think she provided a good explanation for the rest of them, for the reasons for not. I think when you come to a Law Commission report and they give you some draft changes, it's really got to be a question, if you're not going to do it, why not? I think the assumption is with a Law Commission report, because of the very thorough research that they do, that it will be implemented. Now, that's not always the case, and the government can clearly take a different point of view, but this minister has not provided us with any reasons why not. Now, the next point I'll make, and I'm going to put myself in some relatively dubious company here, in that I'm going to support Cameron Slater in the comments that he has made. Well, no, Cameron Slater hardly supports them anymore, but I am going to support Cameron Slater in the comments that he has made around the way that teachers' names are suppressed when there is not good reason for it to happen. Now, the way the Teachers' Council rules are currently drafted, and I'm not blaming the Teachers' Council. There's a $1,000 fine, and they could draft all the rules that they like, and if the maximum penalty for breach is $1,000, then media organisations will breach. But the point that Cameron Slater makes is absolutely correct, and that is that there are a lot of teachers whose names are blackened as a result of the activities of a very few, and having a presumption of openness for the hearings and the ability to suppress the names of the victims, which currently doesn't exist. They're either open or closed. There's not a suppression ability. If we could have that sort of arrangement, it would mean it probably wouldn't satisfy Cameron Slater, who might want to have all of the details, but would go a long way as far as most reasonable media are concerned in order to have or not have names blackened in those particular cases. So what we're hoping, and in fact seeing the Minister of Justice is in the House, and he is bringing in legislation, I presume, to do with the courts. One of the questions I've got is whether for those organisations where the rules are so out of date and much poorer, for example, than they are to do with the medical or legal or accounting professions, whether as he changes his rules for the court, he can do mirror legislation and do a package where they are all considered together rather than considered separately. Because I think it's fair to say that the principles are very similar. In fact, the principles that he has outlined are so good that I picked them up and incorporated them in a supplementary order paper that the House decided not to pick up.
It's part of the criminal procedure bill, so it's actually been tacked on for another piece of it.
Well, I'm sure that the Business Committee, if the member wanted to consider an omnibus bill, would be quite supportive. I'm not sure if the Clerk of the House would be entirely supportive, but I'm sure that the Business Committee would be supportive of an omnibus bill in order to get all of those related matters up together, because I think having consistency through that legislation would be a good idea. You know, it might be the last refuge of fools, but having different rules, especially when you're doing a total rewrite in both areas, doesn't seem to me to be logical, and it might actually help the Ministry get on with their basic redraft of legislation as well. Mr. Speaker, thank you to the House for moving to accept the maintenance of protection against little children who are in care, but unfortunately, and we will be voting for that part at the third reading, because it is a separate vote.